Our next speaker is David Spector from the Akerman firm in Florida. David dedicates his practice to the investigation and litigation of complex fraud schemes, which is his topic today, as well as unfair and deceptive practices on behalf of some of the nation's largest insurance companies and self-insured retailers. David is co-chair of Akerman's Fraud and Recovery Practice Group. His insurance litigation practice has resulted in his in-depth knowledge of the insurance industry. He regularly consults with clients on best practices for fraud detection and investigation. Please welcome David Spector.
Well, thanks very much, and good morning again. So when we were originally asked to discuss this topic, it became pretty apparent to me that for those of you that are in-house lawyers, either within companies or the outside counsel, the extent of fraud happening at your own employers or at your clients probably wasn't as obvious as it is to those of us that practice in this area. So if you look at this screen, each of these entities on the screen have been the victim or been part of a fraud scheme that have made major headlines in the past 12 months. Looking at them, they cross industries. There's no pattern here. We have insurance companies like Travelers, and there's other insurers. We have hotels, we have retail locations, and we have financial services firms. Anthem, one of the largest health insurers, had a breach of its data in 2015 that resulted in 80 million personal pieces of information being released. Target, we all heard in 2014, right before Christmas, was the victim of a complex fraud scheme which obtained about 50 million pieces of credit card information. Those type of retailers suffered every day, and we hear about it all the time. But obviously, insurance companies, which is a large part of our practice, are the constant victims of complex fraud schemes to obtain insurance benefits when they're not warranted. Financial services firms are being held liable every day now for their role in particular fraud schemes, even where that they did not have a direct interest. So the point is that when you look at the statistics, I guarantee you that at your clients and at your employers, there are complex fraud schemes that are ongoing as we speak. So look at the numbers. Corporate fraud, 75% of the entities that responded to the annual Kroll fraud report reported having an instance of corporate fraud. That was up 14% from 2014. Insurance fraud costs the industry about $80 billion a year. As you're probably aware, the Department of Justice has a key TAM entity. So they have filed lawsuits involving $3.5 billion last year alone, but their recovery exceeded that last year because of the trailing cases that were in, and they recovered $26.4 billion. Retail fraud is estimated at $32 billion a year, credit card at $16 billion. Your own good workers that are working there for the good of your entities, well, they caused $7.2 billion of fraud last year alone. But one of the most interesting trends is what we're seeing in social media. So Facebook, Twitter, Instagram, LinkedIn, they are all now platforms for fraud. So we're going to look at some of the cases Facebook has been involved in. But last year, a Harvard student created an algorithm to look inside Twitter within a 24-hour period for malicious tweets that were likely associated with a fraud scheme. And in one day, there were 70,000 malicious tweets identified by this Harvard student. Economic fraud. So PricewaterhouseCoopers puts out an annual global crime report for entities. 1 in 3 entities reported being the victim of economic crime. 1 of 10 discovered those not because they had a process in place, which we'll talk about, but rather that they discovered it by accident. Asset misappropriation is the number 1, followed by cybercrime and bribery and corruption. So we know for a fact that this is affecting all of our clients. And the question is, so what are we going to do about it? And how do we get in front of it? And what do we do when we know about the fraud? So what are our most common types? Let's talk about financial institutions fraud. $30 trillion a year is spent on credit cards. Of that, $16 billion of credit card losses due to fraud exists in the marketplace. There was a 2015 Nielsen report that reported on this and revealed that in the United States, almost 13 cents of every $100 is fraudulent in connection with retail purchases. So the global fraud losses just for financial institutions are going to push well in excess of $40 billion in next fiscal year. So how are these fraud schemes being caught? How are they being discovered? I'll tell you, there's one case involving the Bank of Bangladesh that was recently reported. There was a $1 billion fraud scheme that was targeted to do about $1 billion worth of fraudulent wire transfers and money transfers. How did the Bank of Bangladesh discover this? Not by some great complex fraud analytics, which we'll talk about later on, and not by having lawyers that were watching the henhouse, but because an astute banker got an email to transfer a few $1 million, and the word foundation was simply spelled wrong. It was as simple as that, to have someone look and say, wait a second, something doesn't look right. And we all get those phishing emails. We all get emails, I don't know about all of you, but I've gotten emails that says, hey, I am a so-and-so from some foreign country. They are going to be my next biggest client. I am going to retire off of them. However, they will wire $38 million into my trust account, but I will have to front $10,000 for something, right? Lawyers get caught up in this all day long, and we think, no, we're smarter than the rest. We won't fall for it. And time after time after time, lawyers fall to those schemes as well. Insurance fraud. The estimate is that it's $80 billion a year in losses to the insurance industry. Now, what is these? Insurance fraud is the second largest criminal organized enterprise in the United States today, second only behind narcotics trafficking. When I take depositions of these folks, and if they don't take the Fifth Amendment, and I've done a Fifth Amendment talk for this group previously, if they don't take the Fifth Amendment, they will tell you that these are folks that were involved historically in drug trafficking and other crimes, but it's a lot easier to steal from insurance companies and go under the radar than it is to continue those other type of criminal activities. If you look at auto insurance alone, about $7.8 billion is lost every year there. Now, in my home state of Florida, because of our PIP environment, 31% of that is coming out of the state of Florida alone. So you can see the market share. Those states that have higher limits and mandatory insurance for personal injury protection obviously get hit the largest. So how does that result in litigation, and what do we do as lawyers? Well, in two of the cases that I highlighted, one being the State Farm versus Physicians Injury Care Center, which is just an example of a publicly reported case of the type of litigation that insurers and others that are victims can bring. We proved at trial that there was a complex protocol that existed by doctors who were in cahoots with bad lawyers to overly inflate the recoveries in personal injury cases and personal injury protection. These, what appear to be legitimate medical providers, had predetermined protocols that every single patient was going to get the same thing, and they were going to drive towards the same result, which would result in higher insurance limits. The United States versus Persaud case I included in here because it doesn't only affect the bodily injury, personal injury world. Dr. Persaud was a cardiologist. His scheme was that he would upcode his bills, meaning he would code them at a higher level to get paid more. He would order nuclear stress tests when they weren't warranted. He would alter the results of those nuclear stress tests so he could insert stents into people's arteries and then recover that way. That was a $7.2 million fraud. These things are going on, and if you are self-insured or if you have a high SIR and your first dollars are on you, you are and your entities are paying these dollars out to the fraudsters. Cyber fraud, we hear it all the time, but look at the statistics that are being reported. And the average company, over 81 million cybersecurity events, either attempts to get in, security lapses, 12,000 on average documented attacks, and over 109 documented incidents where confidential information, either of your clients or of your employees or of your own trade secrets, are obtained by fraudsters. The statistics are a few years old, but 3.7 billion data records have been accessed. And if you look at the industries that are affected, it's across the board. Now, I think retail is going to drop because everybody is a little bit more tuned into the risk for retail fraud with the others coming up. And make no qualms about it. As a law firm, we get hit, and I'm sure you all do too, with daily attacks to obtain your records. We don't have to talk about the release of the Panamanian documents that occurred at a law firm a week ago, but the fraud that happens within law firms is real as well. Target, $148 million is what that data breach cost Target. They settled their class action lawsuit last year for a $10 million payment, but the top number is what the estimate is that it cost the company in total. Anthem, 80 million customers were impacted. It was the largest data breach in the history of anyone tracking this type of information. By the way, that's more than 1/3 of the US population. All right, so this is serious stuff. But we're not only talking about your entities and your clients being attacked from the outside, let's talk about the attacks that you have to worry about from the inside. Because the Kroll fraud report said that 81% of companies were the victims of employee fraud, up from 72% the year before. And if you think your senior and junior management folks are not the ones that are looking to steal from you, you're wrong, because 1 out of 3 reported employee fraud cases come from senior management. So the great people that you have that you've entrusted all of the access to all of your sensitive information are probably the ones that you should be looking at the hardest. $3.7 trillion, Kroll estimates, is lost to our clients every year as a result of employee theft. One of my partners brought me a case involving Nike, where Nike had a significant loss because the prototypes of their sneakers, I guess, have tremendous value on the open market for ones that don't ever get sold. So these employees of Nike were stealing these large volumes of these prototype sneakers that never made it anywhere, and they were selling them for between $1,000 and $20,000 a pair. Okay, so the losses to Nike there were a few $1 million. Of course, these folks were prosecuted. But it's us thinking about the assets that our clients have that people don't necessarily pay attention to that are ripe for fraud schemes. So we've talked a little bit about the outside threats. We've talked about the fact that we have to be worried about inside threats. But what if we really didn't have anything to do with it at all? And what if we simply are being accused of aiding and abetting the fraud? Well, these entities here, and I purposely included 2 law firms because law firms can be held liable for these as well. But these 4 entities are 4 very recent cases of aiding and abetting fraud counts. So the TD Bank one involved, for those of you that haven't heard of the Scott Rothstein Ponzi scheme in Florida, Mr. Rothstein was a lawyer in Fort Lauderdale who had apparently a pretty lucrative practice. The problem was that it was all fraud. His practice was employment litigation, and what he was telling investors is that he had all these structured settlements where these plaintiffs would take periodic payments after they settled their case, but they'd only get the money if in fact they kept their mouth shut, the confidentiality clauses. And if they kept their mouth shut, they'd get the full stream of payments. But Rothstein came up with the idea, well, wait a second. Some of these people may want a lump sum payment. They didn't want to get it paid out over time. So if we confront these people a smaller but lump sum of money, then I can offer an investor the ability to get that structured payment down the road. The problem is that it was all fraud. It wasn't true at all. None of these settlements really existed. And he went to his bankers at TD Bank and he asked TD to issue him a series of letters that showed that the money in his trust accounts could only be paid out over time. That was in part true if you believe the scheme. And that in fact there were certain monies that were in his trust accounts which may or may not have been true. So here's TD Bank, wasn't personally involved with the creation of the scheme. Maybe we had a rogue banker, but TD Bank got held liable for about $30 million of those fraud losses. K&L Gates and Jenner & Block. And for those lawyers in the outside lawyers that are in the audience, if you have a client and you're not asking the right questions, and if you have suspicions that maybe the deals are not accurate, in the Jenner & Block one, it was Enron. Enron was purchasing certain assets and they were putting them on their books, but in reality they weren't really purchases at all. And the plaintiffs suffered the losses and sued Jenner & Block, and K&L Gates was no different. And the court said that looking at now neither one of those cases proceeded past the summary judgment, but lawyers can be held liable for that type of aiding and abetting fraud as well. So where do we go with this? Well, the general elements for aiding and abetting are the existence of an underlying fraud, knowledge, which we're going to talk about in a second, either actual or general, depending upon the jurisdiction you're in, and substantial assistance in furthering that fraud. So what does that mean if you're sitting in this room saying, well, what do I need to be worried about when looking at a fraud? Well, actual knowledge, the courts have described as the knowledge element of aiding and abetting, is not identical to the scienter required for the underlying fraud, but rather it requires a reasonable inference of actual knowledge. And it cannot be pled by making conclusory allegations. You must show, in fact, that there was enough information there to show that the person should have known and had actual knowledge of that fraud. In the Bank of America case, 94 plaintiffs sued the Bank of America, alleging that the bank had aided and abetted a known money laundering scheme. Now, here they had pled that the bank had actual knowledge just based upon the size and nature of the transfers, but the court dismissed it because it said, look, these allegations at best would be constructive notice. And constructive notice in an actual knowledge jurisdiction will not cut it, and that court case was dismissed. But here's Facebook coming out, because how many of you have looked at your Facebook page and are told, hey, fantastic, you are the next winner of whatever it may be. If you want to be a tester for the next hot product, well, these are all, I shouldn't say all, generally they are connected to fraud scams. So Facebook sued the entity that was in connection with posting these on Facebook, but the court said no. Where we have an actual knowledge requirement, simply having some idea that these folks may be directing people, our end users, to a fraud scheme wasn't enough. But compare that to where jurisdictions like here in Arizona that have a general awareness. It's a much lower standard. In the Wells Fargo case, you'll see that the court held a showing of actual and complete knowledge that the tort is not necessary. So the knowledge requirement is met, even though there was a lender, didn't know all the pieces of it. So the court's going to look at, in this lower level jurisdictions where it's just general knowledge, general awareness, was there enough there for you to suggest that this was a fraud? And if it was, and you did anything, you didn't have to make the fraud successful. If you did anything to allow that scheme to proceed, then you may be held liable for that. We're going to move through these. I thought these slides were out, but they are in your book as well. So we're going to go past some of the defenses for statute of limitations and equitable tolling. But how do you protect yourself? Right? In the ticket reserve case, there was a third party that was actually selling options to folks. So you'd buy an option, you'd have the opportunity to, if your team won, if you wanted to get a World Series ticket for the Chicago Cubs, you could purchase an option. The problem was that while it sounds good and you would pay out your money up front, it was really one big scam. These entities had no ability to deliver and no ability to get you that Super Bowl ticket that you wanted. But the cause of action did not proceed because the disclaimers that were on the Ticket Reserve's webpage were pretty clear. And it said, and if you make this clear in your deal documents, or if you have retail contracts like these, that under no circumstances you can get yourself out of being held liable for these type of frauds. Same thing in the Stanfield case that's also in your materials. There, Meridian hired Credit Suisse to facilitate a transaction. There was a bankruptcy issue, but the allegations were that Credit Suisse had aided and abetted in their investment banking capacity the folks at Meridian. But the court said no, it's pretty clear, because the language in the governing documents made very clear that Credit Suisse was not going to be liable for any fraud because it was a plaintiff that had to independently evaluate it. So there are options and there are ways for you and your clients to go ahead and protect yourself. And I'll leave you with, how do you find fraud before it happens? There are tons of opportunities for us to use analytical tools and consultants to run analytical fact patterns and to see how often certain money transfers are happening, or in the insurance world, how often certain providers are billing, or facts like that. But let's just go right to the Bernie Madoff fraud scheme. How did Bernie Madoff unravel? It unraveled because the FBI received a tip from a particular person in the financial industries who said statistically he had ran all of these purported returns that Mr. Madoff was offering, and it was statistically impossible. The point here is, in your own companies, you have data sets. You can look at series of transactions, you can look at frequency, you can look at amounts, and patterns will develop if you have the right analytical tools. So don't wait until such time that you receive a subpoena or a notice of a lawsuit or a suspected loss. Be proactive. Look at your own data, look at your own customers, and figure out ahead of time. So with that, I appreciate the opportunity to speak with you all, and enjoy the rest of our program.